Hi, my name is Nick. I am an attorney in California. And if you have had four or more points on your driving record within 12 months, or you've gotten into an accident under circumstances that may warrant suspicion on your continued fitness to drive in California, you may have been served with a notice of suspension and or a driver safety hearing. Usually it's going to be both. So if your license is going to be suspended, you do have the right, you do have the due process to appear at a hearing with a DMV hearing officer. And this can be done remotely. You don't have to go to Sacramento. And here are some tips because I just finished one today that went very well for my client. And they were obviously panicked that they were going to lose their license for more, at least 6 months, maybe even over a year. And what ended up happening, to get right to the chase, is that the officer allowed my client to show next week at a DMV office that my client is a safe driver. So it'll be a behind the wheel test. And after that, which I know my client will pass, my client will have her license fully reinstated. And her license wasn't even suspended today. They gave her a permit that allows her to drive with an adult 25 years or older until the DMV behind the wheel test. So here's what you can do. Obviously, I cannot give any implied or express promises or guarantees of any particular outcome. Every case is different. I am an attorney, but I'm not your attorney unless you and I have an active engagement agreement in place. Okay, since disclaimers are like oxygen to attorneys, I just had to get those out of the way. Let's do it. So first, request the state's evidence. You want to see what evidence they have against you. This is urgent because you may only have, in some cases, 2 weeks from the date of the notice to the date your license will be suspended. It goes without saying, but maybe it doesn't. Do not drive with a suspended license. You're going to have probably at least 2 points in your license just from that. It will not work for you. You will get caught. Things will happen. You'll get in an accident that wasn't even your fault. There'll just be some karma, and your difficult life will be made even more difficult. Do not drive with a suspended license. There are always alternatives. So you want to request the state's evidence, and there's a couple ways you can do this. You can write to the DMV, you can email the DMV, and this should be verified, but normally the email address that you would use is ladds@dmv.ca.gov. If you know the NATO phonetic alphabet, it's Lima, Alpha, Delta, Delta, Sierra, Sierra, Alpha, Charlie, Romeo, Alpha, Mike, Echo, November, Tango, Oscar, Oscar, Foxtrot, Foxtrot, India, Charlie, Echo at dmv.ca.gov. If that was too fast, then you can play the video back in slow-mo. And then phone number 833-543-7703. The hours of the DMV office are government hours. Therefore, if they can take time off, they will take time off. It's very difficult to get a hold of them. You're better off sending an email. You're almost always better off sending an email when it comes to anything legal or important because you need that paper trail. It's very difficult, if not impossible, to legally show what somebody said to you over the phone. More often, they won't even answer. And that's just because they're very busy, not casting any aspersions on the DMV. Okay, they're there honestly to protect all of us. And these DMV hearings are to make sure that safe drivers get another chance, unsafe drivers, where they don't even bother to appear, are taken off the road. It's better for all of us. So you want to be able to send an email that's professionally worded and ask for all the evidence that the state, because the state is essentially the plaintiff here. They're not a prosecutor. This isn't a criminal trial. It's an administrative hearing. They're not technically a plaintiff because it's not a civil trial, but it's more akin to a civil trial than a criminal one. So it's you, the driver, the resident of the state of California versus the state of California. Therefore, you're asking that the state provides all the evidence that the state intends to provide at your hearing, including police reports, accident reports, and especially witness statements. You want to be able to prepare. This is basically like discovery. And you want to be able to go through the discovery, see what the state has, so you can prepare a defense. You can read through it, you can identify what the weaknesses are. Because during the hearing officer will ask you, do you have any objections to each exhibit? And that is where a lot of people get it wrong. They start their argument, they start contesting and saying, this wasn't my fault. No, focus on the question being asked. You don't want to lose the hearing officer. In other words, you don't want to lose their favor. You don't want to make them annoyed or angry, which a lot of self-represented litigants will do. They'll have technical problems, they'll have audio problems, they will be rude, they'll be impatient, they won't be prepared. Think of yourself as an attorney. What would an attorney do? How would they dress? How would they appear? How would they sign in early? How would they have everything laid out in front of them, ideally on the screen, because these are most likely electronic exhibits that you've sent to them. You want to have your exhibits, and in this case, think of yourself as the defendant, even though it's not the correct title. So the way this goes is the plaintiff, the state, has numbered exhibits, the defendant has lettered exhibits. Have an opening statement prepared, have a closing argument prepared. You will almost never go wrong if you over prepare for almost anything in life. This is no different. So for this, make sure that you've had a chance to review the government's exhibits. And if they are flawed, then you would object. But that's because maybe lack of authentication or hearsay. And hearsay is tricky here because hearsay is allowed. Obviously, they'll probably bring in the officer, or most likely, they won't bring in the officer, they'll bring in the officer's statement. That's hearsay, out of court statement brought in for the truth of the matter, asserted, et cetera, however you want to define it. But basically, the state is saying what they heard someone say. And oftentimes you'll have like compound hearsay. You'll have the officer quoting a witness who, that's like hearsay on hearsay. The witness is not there to testify. The officer is not there to testify. So make sure you bring that up. So admit the exhibit, most likely, if there's no, facial defects, there's no challenges for authentication, et cetera. But challenge the exhibit piece by piece where things don't add up, such as this is the witness testimony, but this witness was in the car of the driver that hit me. That witness is biased just as that driver is. This officer wasn't there. This is the officer's police report. How do they know that driver 2 was hit by me, driver 1? They weren't there. Point the officer's attention to the fact that there are no dash cam recordings. There are no traffic camera recordings. There are no firsthand testimonies, if that's the case. If you do have a witness, you want to bring them in. You want to have them testify. They'll be sworn in. You want them to be able to give their testimony that is advantageous to you. And make sure you understand what they're going to say before they say it. Again, this is not a criminal hearing. It's an administrative hearing. It's usually under the California Vehicle Code. It's conducted by a hearing officer. It's not even a judge. And they are there to determine whether your license should be suspended or reinstated. And you have the right to hire someone like me, an attorney. You have the right to present your evidence. You have the right to question the state's witnesses and the state's evidence. It's like a mini court trial. If you've never been in court, if you've always wanted to be in court, you watched Ally McBeal, you watched Suits, you watched A Few Good Men, you did all your training by Netflix. This is your chance to put your skills, quote unquote, to the test. And it's a very low bar. Okay, so the bar here is by what's called preponderance of the evidence. That is the state's burden. That's their statutory burden of proof that they have to satisfy. And where a lot of people get this wrong, especially in small claims, which is not the purpose of this video, small claims just like this is preponderance of evidence, which is what most civil trials are. Preponderance of the evidence. What does that really mean? Does it mean like, oh, it's an overwhelming amount or it's a large amount? It just means if you have those two proverbial scales of justice, the one you see on like lawyers' desks for ornaments or their business cards, the scales are evenly weighted. If the scales are evenly weighted, and what this means literally is that if the state is purporting to show that driver 1 hit driver 2, let's say it was an intersection and both cars were making a left turn, all right? So they went like this, all right? And they hit. How is it by preponderance of evidence? Meaning more likely than not that you hit the other driver versus the other driver hit you without corroborating evidence, without additional witness statements, without video footage. Why is it more likely, based on the exact same evidence with no additional evidence to just tip the scale just a little bit in the state's favor, that the state should assume that you caused an accident when both parties could have been likely at fault. Now, where that wouldn't apply, where it would be like per se preponderance of evidence against you, is you were caught driving in a one-way road and you're facing the wrong way. Okay, that's going to be pretty much hard for you to say, well, it's just as likely that all the other cars are going the wrong way, even though the sign said I was going the wrong way and all the other drivers did, and it was pretty much obvious by the facts. Okay, so don't be an idiot. That's helpful advice. You want to make sure that if reasonable minds could disagree, then you want to emphasize that disagreement. Okay, so that's where the state often will not meet their burden if it's a wobbler. And bring up the accident intersection. Go on Google Earth, do Google Photos. There's a lot more that you can do than maybe you think you can or maybe you want to. This is your ability to drive. This is serious. Go on Google Earth, go on Google Photos, get a picture of the intersection, high resolution, be prepared to share it. Make sure you know how to operate Teams, make sure you know how to share a screen, try to do a practice run with somebody on Teams if you can before, and annotate the picture if you can. Oftentimes the state will have their own annotated exhibits. They're usually in pretty bad black and white quality. If you can bring your own in, which I did today, that was very helpful, I think, because it showed that both parties were at an intersection and there's no way to show who had the right of way. There's no way to show who had the green light. Yes, my client had to stop before they turned right, but the other party may have had the green, but there's no proof, okay? There's no real-time evidence of that, which, before I forget, if you had a dash cam, if my client had a dash cam and they were in the right, that would have been dispositive, meaning slam dunk, not literally, but slam dunk. If you have a dash cam and you can bring in the footage, you can send it to the state to show, here's what happened, here's what caused the accident, I was stopped. If you have a Tesla, you have a dash cam. You have more than one dash cam. You have 5 or 6 dash cams in almost all angles. Don't forget to use your footage. Don't forget to maintain your dash cam. Make sure it's recording. Test it at least once a year so you know how to download the footage. You're figuring out pretty quickly that, oh my gosh, my memory card doesn't even work anymore because those will degrade. Teslas are great. Get the most reliable, maybe the most expensive memory card you can get with the most endurance. And then it will pay for itself so many times over for your insurance if you're in an accident, and it'll prevent you from losing your license if you're going through something like this. And it's your allegation that you're not at fault, but it doesn't matter what you claim. Obviously, you have an interest or a biased party. The weight that your oral testimony is going to have on the hearing officer is no greater than the state's, and realistically, probably less than. It's your interested, self-interested, biased testimony against what's supposed to be a third party, credible testifying officer, even though they're giving like written declaration. They're not going to be there in person, most likely. The officer's written declaration is usually going to be taken with probably more credibility than yours. The officer doesn't have any skin in the game like you do. Emphasize your safe driving history. My client, before this incident, which I emphasize was of questionable circumstances, had no accidents for over 10 years. And also, what a lot of drivers get wrong is they think that they should downplay the number of miles they drive each year. And I think their thinking, erroneously, is that if they show they only drive like a few 100 miles a month, maybe a few thousand a year, very slight, they think that'll go in their favor because they'll show like, oh, look, I don't have many opportunities for a crash. No, the way to think of it, the way to properly think of this is the opposite. You want to show that you drive a lot, because the more you drive, the more chances you have for an accident. And if you've driven 10 years with no accident, and that's why you want to get your DMV driving history, don't make a claim that you haven't had an accident in 10 years if you had one and you think the DMV didn't find out about it. They probably know. But conversely, don't do a mea culpa prematurely. Don't say, Honor, out of, full transparency, okay, I had 3 accidents over the last 10 years. They weren't reported. I just want you to be totally honest. Okay, don't give the state evidence against you that the state doesn't already have. Okay, it has to be within the confines of what the state has against you. Don't give them an alley-oop. I know nothing about sports, but I think that's something that they do with a ball in a ball sport. Don't help them out. by giving them like it's an unforced error for you. Okay. I think it's another sport metaphor, but I am aggressively ignorant when it comes to professional sports. So I'm a lawyer, not anything else. So know the standard of proof. It's not beyond a reasonable doubt. It's just preponderance of the evidence, and make sure that you have a trial binder, just something more than nothing. Put it all down. It'll force you to organize your thoughts. It'll force you to label the exhibits. You don't have to necessarily send this to the DMV, but you'll have things at the ready, and you'll be able to incorporate the DMV evidence in your trial binder and be able to annotate it and refute it, and also show the exhibits that are most beneficial to you, along with the intersection, along with maybe your medical history. If you want to share that, you don't have to, but you can, to show that you have no medical condition. That was a concern for a client before, where the state, even though she had no points in her license, the nature of the accident and how she was after made the citing officer or the investigating officer who did the police report very suspicious that this person may have had some medical complications that would prevent them from being a safe driver. So if you can get a clean bill of health by the time of your notice of hearing and your hearing, that's great. If you can't, you need an extension or continuance, it's called, you might be able to do that. Email the hearing officer, get in touch with the hearing officer. If you can do it by the email address I gave you at the beginning, sorry for the hiccup, that's even better. Now you have a written paper trail that you've made comms with the hearing officer. You will have the hearing officer's name presented to you before the hearing. Make sure that you don't have technical problems. Okay, I have a pretty reliable setup here. The microphone is always set up. I have the headphones, and I have redundancy. So I can also use my laptop as a backup or my phone. This is usually going to be on Teams. You can probably also call in if you don't have exhibits, but the disadvantage of that is that if you're calling in, you're not sharing your screen, you don't have the ability to, you're probably not going to be able to see what the state is offering in against you. So that's why it's better to call in on Teams. It's a privilege, I guess, that we are allowed to appear remotely and use Teams rather than have to drive to Sacramento for an in-person hearing. And it's perhaps a privilege that we even get the due process, that they don't just say, hey, officer thinks that you're unsafe to drive, therefore your license is suspended for a year. So buy a bicycle. I hope you found this helpful. If you did, I'll make more of them. And if you didn't, well, I know I'll hear from you because it's YouTube. So all the bad comments rise right to the top, and they're expressed early and often. But I am an attorney. I am available. My email address, hopefully I don't get spammed, is nick@nickcohenmeyer.com. I specialize in landlord-tenant disputes, residential and commercial, along with consumer disputes and traffic. And if you need help preparing for your small claims suit, I have extensive experience with small claims court as well. I hope you have the day you deserve.